Now I know I'm dealing with a guy that is somebody I really don't need to be associating with. I think he's friggin' crazy. That's what went through my head. You know, this guy is out of control.
That's a former neighbor I interviewed exclusively last night, said very nasty things about Michael Dunn. Said he was a racist, that he had propensity toward violence. The jury never heard any of that. Now, I've been trying to make the point here as to why I think there is a real problem with this prosecution. By the way, the jury suggested that they may be hung on one count. Could it be the key count of first-degree murder? Here's the thing. A good prosecutor, an effective prosecutor, doesn't just disprove things. They proactively prove something. So here's Prosecutor Juan Martinez proactively proving, not that Jodi Arias was lying when she said she didn't murder Travis Alexander, but proactively proving that she did, and here's exactly how she did. Watch.
This love, well, she rewarded that love for Travis Victor Alexander by sticking a knife in his chest. And you know, he was a good man, according to her. And with regard to being a good man, well, she slit his throat as a reward for being a good man. And in terms of these blessings, well, she knocked the blessings out of him by putting a bullet in his head during one.
And he goes on and on and on, proactively proving every step of the way how she stabbed him near the chest, how she stabbed him in the back over the sink, how she dragged him down the hall, how she slit his throat ear to ear, 6 inches across. Now, here's my problem with this. I'll go to Joey Jackson, legal analyst. This prosecution seemed more intent on proving that Jordan Davis, the victim, did not have a gun. That Jordan Davis, the victim, did not threaten the defendant. That Jordan Davis, the victim, did not exit the car to attack. In other words, the defense framed the debate and put the prosecution on the defensive. And so I think it should have been the reverse, with the prosecution proactively saying, here's what Michael Dunn did. He killed this kid, and he thought he got away with murder. They should have said that in the opening statement, not just the closing statement. They should have said the closing statement. He would never have reported this crime. He didn't realize that somebody had written down his license plate. When he left, he thought, I'm never going to say a word about this. Nobody's going to be knowing that I'm involved ever. I'm going to go about my life. They should have started with that premise and put them on the defensive, as opposed to trying to prove all the ridiculous allegations the defense made.
You are on fire, Jane. Absolutely. It's a very good point. Listen, the bottom line, though, is this. There are very few Juan Martinez's in the universe, okay? Juan Martinez is in a class by himself, and so clearly he's passionate. He's on top of his game. He does his job very well. However, there could be, that's right, Jane, fan off a little. You're on fire. But there's also another point here, and that point here relates to the issue of premeditation. Now, under common parlance, the everyday person believes that premeditation is lying in wait. I'm going to plan a week. I'm going to plan a number of days. I'm going to plot my strategy to your death. Very few people could conceptualize what we know to be true in the reality, that premeditation can be formed like that. And so if there is a debate and there is a view, it's looking and analyzing over whether Dunn formed that premeditation by reaching in that glove compartment, by taking that gun, by taking that safety off, by clicking it back, by aiming, by pointing and shooting. And that's what the jury may very well be finding problematic to get to the conviction of first-degree murder.
But do you see what I'm saying, Eric Guster, criminal defense attorney? I mean, it's as if, and, you know, sometimes people would get confused, and they would confuse the prosecution and the defense, and they'd say, well, the defense, and then they'd realize, no, oh, that's the prosecution. It's almost as if this young man who can't speak for himself because he's dead was on trial.
Mm-hmm. Well, you raised an interesting point in reference to self-defense. Once self-defense is raised, the prosecution must prove that it's not self-defense. Right. They have the burden of proof beyond a reasonable doubt that it's not self-defense. Right. So they are on kind of the defensive to prove that Jordan did not have a gun, that he was not the aggressor, because that's their burden of proof. Once that issue is raised, they have to prove that case. That's why self-defense cases are very difficult when you have different circumstances. I don't believe for 1 second Jordan Davis had a gun, but we don't know what these jurors are back there thinking, because you have people from all walks of life and all different situations.
Well, yeah, I mean, you know, it's almost as if the way the defense cleverly laid it out. The default good guy is the defendant, and the default bad guy is the victim until proven otherwise by beyond a reasonable doubt. There's something wrong with a system like that.
Come in as a default good guy.
Hold on, one at a time. I'm sorry. Go ahead.
Yeah, Jane, cases can be won or lost in jury selection and opening statement. And you're right. If you look back at John Guy's opening statement, he started off by admitting that Jordan Davis, he did escalate things. He said things he shouldn't have said. He was saying F-bombs. He was being disrespectful. He should have never, ever focused on any of that in opening statement. Jurors decide cases early on whether we like it or not. One other point I wanted to make is, and I'm going to get back to this again.
Let me just go to Wendy, because you wanted to weigh in on this part first, and we'll go ahead, Wendy.
Sure.
Look, there are a lot of things about the system that seem crazy in a case like this, but the bottom line is the prosecutor is held to a different standard. They can't do what Juan Martinez did most of the time. I mean, that guy was sassy. And if you did that in Massachusetts, that would be reversed on appeal. So what happens in most states is you can't argue in your opening statement. You have to only declare things, and you have to put the crappy stuff out there to get the jury ready for it so that they don't go when they hear what they hear. I think the prosecution did a good job with what they have, but racism is in the room, and that makes everything harder.
Well, it's the big elephant in the room, but the jury didn't hear anything about it. Not a word.
Exactly.
But not a word.
But you need to put out your
Jane,
bad stuff and let them know that you're
all right, on the other side, we'll get to it, and your calls are lining up. We'll take those too. We're on Verdict Watch. They're back tomorrow morning, 9 a.m. Meanwhile, what are they thinking right now as they head in their truck back to their hotels? Are they talking to us? Are they talking to each other?
Round after round after round. He wasn't shooting just to scare them off. He was shooting to kill. He was shooting for his targets and aiming at Jordan Davis.